everyone. I'm glad to see everybody here. And let's start with a list of questions. We have 5, so I'll go through those, then give everyone a quick update, and then we can go from there. So, first question. The master insurance policy from our HOA included guaranteed replacement costs and the cost of cure to rebuild the house. That being said, do we still need to hold off the sale of the property before receiving the settlement? We have other losses such as contents and expenses related to the settlement. That's something that we would have to look at in more detail. We need to see what the exact language of the policy is. When you say from our HOA, that's what gives me pause. So what I would say is send that in to us and let's go through it in more detail, because I don't want to give just kind of off the cuff advice on something that's that critical. The language that is used there really is term of art. The specific language that is used there, each of the words are terms of art, and so I do not want to give the wrong advice there. So I would say contact me either by email or phone, let me get the policy, have our experts look at it, and then we can go from there. Number 2, when will we be notified that our claim will be submitted? So typically we don't notify people. If anybody wants to and they want to see it before it gets submitted, that's fine. Just email us. We'll make a notation for you in your file and we'll make sure to send it to you. But typically what we do is just submit it as soon as it's ready. Number 3, this is in regards to ALE. I have close to $480,000 of ALE money on my policy, and I've spent approximately $54,000. Nationwide will not pay me out the difference. I was told I could only look for a rental for the approximate amount I was spending on my mortgage. This put me in an 800 square foot home after being in a 2,500 square foot home. Can I claim the dollars they have not paid out? So the answer to that is not as part of the lawsuit. You can certainly claim the annoyance disturbance damages in terms of being in an 800 square foot home, whereas previously you were in a 2,500 square foot home, but you can't go to PG&E here to the trust and say, we did not receive the full amount. It sounds to me like the advice that was given here by the insurance company is wrong, because it has nothing to do with the amount that you were spending. You are entitled, under the language of most policies, to receive like, kind, and quality. Those are the industry terms that are typically used. And so like, kind, and quality would be to put you in a furnished 2,500 square foot home. It wouldn't be to put you in an 800 square foot home. So there may be a bad faith case there against the insurance company, but you can't go to your you can't go to the trust and say, I want the difference between the 480 and the 54. So that's another one. I would say reach out to me and let's see if there potentially is a bad faith case that we can refer out. Number 4, what is being done to expedite victims' compensation? So we had a meeting of the TOC today, the Trust Oversight Committee, with the trustee and the claims administrator. I'll get into that a little bit more later, but it looks like everything is on track for the questionnaire to be ready on August 17th and for submissions to start on that date. And then finally, what are the hours of the trustee and claims administration? The claims administration is working full time. So if you have questions, for example, if for some reason you want to contact Brown Greer, you can certainly do so. A lot of times they're reluctant to talk to people who have attorneys. On the other hand, a lot of times they will speak with you. So again, if you want to do that, you can. They won't give you legal advice, but they will answer technical questions. So those are the 5 questions that were submitted. Let me give you kind of a quick overview and then we'll open it up for other questions. So as I said, we had a meeting today of the Trust Oversight Committee. Most of it was focused on what is happening with the trust and what is going to happen in terms of the stock sales. And so we talked about when that's likely to occur, the manner in which that's likely to occur, a number of different things. Obviously, we don't want to sell right now because the amount is going to be significantly less than what we need in order to get everybody paid in full. So it doesn't look like that's going to happen anytime soon, but there's enough cash to last the payouts of the trust for quite some time in terms of payouts. The other thing we were focused on today was the third-party claims, and that is maximizing the amount that's going to be coming into the trust. It looks like there's about $850 million in insurance, and we want to get as much of that as we can to add to the trust. There were also some taxation issues that came up that we're trying to work out. The trustee at this point is being told by his attorneys that he has to issue a 1099 to individual claimants. We do not want that to happen. We do not believe that it's necessary. So one of the things that I did today was spoke with another attorney, a gentleman named Robert Wood. He's a tax attorney in San Francisco, and we're going to work with him to get an opinion that will counter that, because I don't think it's in anyone's interest to get a 1099. If 1099s have to be issued, then in our view, they should be issued to the attorney, and then the money will come into us. We will go ahead and distribute the amount after fees and expenses are deducted to the individual. Then the individuals can work with their own tax preparers to put the money into the appropriate buckets and thereby minimize what, if anything, has to be paid in terms of state and federal taxes. That's the way we've always done it. That's the way we want to do it this time. And so that's what we're going to be working on. I think the trustee is going to be receptive eventually, but that's a fight that we're having for right now. So that's basically it in terms of the overview. We've just been working up the cases, getting them ready to submit. Again, they told us today that the questionnaire is on track to be ready to go on the 17th of August, which would mean that once that happens, we can start submitting, and then we'll see in terms of when the payments are going to start. They've told us that they want to process a number of claims so that they can put together at least a rudimentary budget before they issue the first ones. So we're not going to know exactly when that's going to be. Again, we've been talking about it being sometime in October. Obviously, we hope that happens, but we'll just have to see what happens with the initial submissions, and then we'll go from there. So that's all I have in terms of an overall, just kind of an overview. Let's open it up, and who's got questions?
Hi, is it Gerald?
Yeah, Jerry's fine.
Jerry, Amber Watkins here. Is there a way to see sort of our full file, like as it relates to, let's see, there was a checklist of items that you guys were going to provide. Can you refresh my memory on sort of the broad overview, what that checklist was?
Sure, it just depends on what type of a case you have.
Okay.
So if is it a home loss? What's your situation?
Yes, home loss and then personal damage, distress. That's how I would describe it at a high level.
Okay. So what we need from you then would be the personal property list is the most important. The
Okay.
experts will make the determination on any real property damages,
Mm-hmm.
but we do really need that personal property list from you. And then the other thing that we need are what they call the gateway documents.
Mm-hmm.
So that's showing that you live there. So driver's license, if you don't have a driver's license for some reason, then if you have state ID, just something showing that you lived at the address. If you owned it, then the deed, things like that.
So is it, if they've already did an assessment of your property loss, then you guys had hired an independent firm, I believe, to do that?
It depends. There are different experts for different categories. So there's contractor experts, arborists, erosion. It just depends on what you need.
Okay, so is
Yeah.
it possible just to see like what you guys would be submitting, like receive those as a file, just to make sure it's comprehensive and
Oh,
representative,
sure.
like what our expectations are?
Yeah, so just send me an email, and what we'll do is we can send you the reports,
Mhm.
and then you can take a look at it and let us know what your thoughts are.
Yeah, my other little complication is I'm sort of separated from the other individual that I,
Mm,
was lived
sure,
with. So,
understood.
would like when you say personal property list, are you referring specifically to content list?
Yeah, yeah.
Okay.
So, and there's two ways you can do it when you have a situation where there's a couple who are living and they separate. You
Yep.
can each prepare your own one,
Uh-huh.
or you can do a joint one and then agree to split it. A lot of times people find that to be easier,
Mm-hmm.
but it just depends on your unique situation. With some people, it's better to do separate ones. So you guys just let us know how you want to handle it and we can do it that
All right. Thank you for your input.
way. Sure.
I have a question.
Sure.
I have emailed your office several times, but I've never received a reply. Would it be better for me to call?
Well, I'm concerned about that because you definitely should have gotten a reply. Can you let me know what the address you're emailing is?
Oh, gosh, not right now. I'm on my phone, but
Okay.
I mean, I don't want to juggle it and lose you.
Oh,
But the
sure.
question I
Go
was
ahead.
emailing you about is I did receive a grant from FEMA, and am I required to repay the grant? Do you know?
Yeah, no, you're not going to have to repay the grant. Now, they may deduct it depending upon
Mm-hmm.
how much information the trustee has. If they
Okay.
ask for it, then obviously we have to provide it. And there is an argument that for certain types of grants, FEMA is entitled to be reimbursed. So we have to look at that and just see exactly how it plays out. But what I would
Okay.
say is, because I want to make sure that we resolve this issue, can you just email me when you get a chance the address that you're emailing, and I'll see what the problem is, because if there's a spam issue or something, sometimes things get caught, and I want to make sure that we're responding to you quickly. So that
Okay. So your email address is Jerry Singleton?
it's just Gerald, so
Okay.
GERALD at
Okay.
SLF, so Sam, Larry, Frank,
Yeah. Yeah.
firm.com.
Okay. Firm.com. Okay, great. And I think I have pretty much sent in everything that I need, except for I was going to look from the paperwork from FEMA to let you know the exact amount that I was awarded money and I got a grant. So I'll dig that paperwork up. But I think I have all my information with you on file. I did a phone interview. I sent in the property list, and I mean, I think I've got everything. So I was just wanting to double check and make sure that I was correct. So
I'm
I will
glad.
definitely,
Go ahead.
I'll definitely email you.
Okay, great. Because I do want to make sure that we get that problem ironed out. I don't want there to be a situation where you're reaching out to us and we're not getting back to you. So we'll figure that out.
Okay, great.
Okay.
Looks like
Okay.
Jerry, we have a question from Mr. Parsons.
Sure, go ahead.
Can you hear me now?
Yes, we can.
Okay, thank you. I'm representing Earl Persons, my brother. I think we've talked before.
We
My
have.
my question is,
You're on mute. There we go. Yeah.
you better? Okay. My question is about the questionnaire that's going to come out on the 17th.
Mhm.
Is the claimant responsible for filling out that questionnaire, or are you guys going to fill it out for him?
No, we're going to fill it out, and that's the issue, because the way they're doing it this time is a little different. In the past, what we've done is we prepared what we referred to as a mediation packet. And so we had a demand, and that was broken down. Basically, it was a very long spreadsheet that had subparts. So we'd say real property, and then we'd put in the damage to the home, and then we'd have a line that went over, and we would provide the amount and then the basis for that. So we'd say contractors rebuild estimate, and then we'd list that as Exhibit A, and it would be attached, and you'd go all the way down. This time they've asked us not to do that because they want everything in a computer. So you have to, and they're not going to do it on any kind of a hard copy. You've got to log on, go into the portal, and then enter all that information into the questionnaire. So that's why nothing has been submitted yet, and that's why we won't have a hard copy to send to you. We can obviously send you any reports if you're curious about, you know, tree value or erosion or anything like that. But in terms of that actual questionnaire, that has to be submitted electronically and sent in. So that's how we'll submit, is we'll take all of the information that we've gathered, we'll put it all into the questionnaire, then we'll submit that.
Okay. We had requested all of the reports that are going to be used for Earl's claim. We haven't received anything back from.
Okay, then just send, if you could, again, just send me an email and I will get that to the right person so they can send them. And please put in if you want them sent to you, to Earl, whomever, and then we'll go ahead and send those out.
Well, I'll have it sent to Earl's email account because I have access to it, and that way we don't have to worry about two different places to go. Okay. Thank you very much.
Sure. Yeah. All right. Who's next? Mr. Brass.
I have, expenses over the last 2.5 years that I've incurred, like HOA fees, roof assessments.
You cut out there. Mr. Brass?
Yes. Hi.
I'm sorry, you
Hold on a
cut out
second.
there. You said HOA fees, roof assessment, and then I lost it.
Can you hear me now?
Yes.
Okay, good. So I have expenses I've incurred over the last 2.5 years and not been able to live at my condo of HOA fees, roof assessments, things like that. Can I submit those for payment?
Typically, no. And the reason for that is the reason that you're able to recover the alternate living expenses is that the idea is that they understand that you have to maintain your pre-existing, whether it's a mortgage, whether it's HOA dues, whatever it is, you have to pay those. So that's why they have to pay your entire ALE. Now, what you can do, because you haven't been able to live there and you haven't had the enjoyment, is as part of your non-economic damages claim, you can list that as one of the damages. In other words, you're in a different situation now, you've been paying for this other home, and you haven't been able to enjoy it. So that's part of the non-economic damages.
Okay, so this was my brother's home. He passed away a couple months later, not due to the
I'm
fires
sorry.
at all. But so can I took over, I'm the trustee. Can I claim my living expenses? And I live in Colorado.
Unfortunately, you cannot. The reason for that is that it's only if you're actually displaced as a result of the fire you can claim it. And one of the things about California law, and frankly, I do not agree with this, but it is the law, and there's really nothing we can do about it. The way that California law works is that non-economic damages, unfortunately, are extinguished when a plaintiff dies. So you can definitely recover the economic loss associated with it, but not the non-economic.
Not even the fact that I couldn't rent it out.
Lost rents, that definitely is something in your situation that I think would be reasonable to pursue, because there won't be any non-economic damages. And what they don't want is for you to be able to double recover. loss rents and non-economic. But since you cannot recover non-economic, then I think loss rents would be appropriate. So if you want to make that claim, then yes, I would encourage you to do so.
Okay, great. Thank you, Jerry.
Sure.
I have a question, Jerry.
Sure.
I'm just curious about on the questionnaire, how the narrative is composed. So do you cut and paste from everything we've sent in, or how is that information input subjectively? I'm just curious.
No, that's a good question. So what we're going to do is, we just create Word documents for the narratives, and what we're doing is describing the three categories: the proximity to fire, and threat to one's life or witnessing loved ones. That's one. Number two is how it's affected your life since then. So the annoyance, disturbance, inconvenience, and mental anguish. And then three is cherished possessions. So we create those, we make a Word document, and then we'll attach it as an exhibit to the questionnaire. The questionnaire is more focused on things like identifying information, all of those things, and then we'll attach a number of documents, whether it's the contractor's report, arborist report, the narrative, all of those things at the end.
Okay, so can we have an opportunity to look at the narrative before it's submitted?
Absolutely. Again, if you want to look at the narrative or anything else, please just let us know. It's most helpful if you can send us an email. That way we can make a notation in your file, and we'll know not to submit until you give us the go-ahead for whichever portions you want to review.
Okay.
Hey, Jerry, one quick question. So,
Sure.
And this is, I think you're reiterating what someone just asked, that the house burned down in an HOA, a lot of fees, a lot of things associated with it. Is there any recouping of those sums? Mortgage fees, any of that?
Unfortunately, no. And that's the way the law contemplates you getting compensated is for the ALE. And so what they're saying is you have the right to require the defendant who burned down the home to fully compensate you for the alternate living expenses. And then as part of the non-economic claim, you can say, I had all these expenses for my home, but I wasn't able to enjoy it, and therefore I'm entitled to additional money.
Okay. Hey, last thing. So had to move out, house burned down, had to move out. This is referring to a rental. Had to move out, get a much more expensive place because there was no place to rent. What can you, the insurance company paid for like half the rent. Can you claim the second half?
Yeah, you can, because the issue is, the question is, in that situation, what changed? So if you're, prior to that, you were paying, and I'm just using numbers, $1,500 a month, and then you went to paying $2,500 a month, then you're entitled to that difference, the $1,000 a month, until your rent went back to where it was before.
Thanks.
Sure. Looks like Mr. Amberg has a question.
Sure. Go ahead, Mr. Amberg.
I believe I've unmuted myself.
You have. I can hear you.
Okay, thank you. Basically, I rented. I had renter's insurance. Most of my possessions were not destroyed. I had ash, smoke damage. The deductible was like $2,000, which I really felt like the insurance compensated me satisfactorily materially for what I claimed. Which is mostly lodging while I could not live here in Paradise. My primary question is kind of personal, but I'll make it public here. Has to do with the emotions and trauma that I dealt with and still deal with. And I just wondered, I believe I've answered questions and had on a phone interview and such.
Mhm.
But do I do anything further at this point?
No, and that's why we do the phone interview. Is we want to get your story, because obviously everyone's story is different, and then we'll put that into the narrative. And so once we get that, then we'll submit it along with the questionnaire. The one question I did have for you is, did the insurance company reimburse you for the deductible now that they have settled?
No, they did not. It was difficult just to get reimbursement until I found housing that was permanent. I just did what I could do myself. And I discarded things that I just didn't want to have to deal with it. I just wanted to get into permanent housing here in Paradise, which I've been in since March of 2019. So, but the real thing that has continued and was the hardest part is the trauma and emotional thing. So for that reason, I just want to be sure that I've done what I should do for a claim.
Yes, it absolutely sounds like it. If there's anything else we need before we submit, we'll certainly let you know. But as long as you had the interview, then the team will prepare the narrative and we should be ready to go.
Okay, very
Okay.
good. Thank you so much.
Sure thing.
I have a
Yes.
que-
Yes,
Can you hear me?
I can.
So it's kind of general questions about how this is all going to be submitted. So when we started this, I believe there were 77,000 claims. I think probably some of that has been reduced because there were duplicative people involved. So I don't know what number it's down to now. But when that portal opens, I would assume all the law firms are going to just be going crazy trying to shove all their information through this portal, whatever a portal really is.
Mhm.
Is that going to impact different law firms and how they get kind of set up for number one, number two, and their claims being looked at by the trustees?
No, and again, I can only speak to my firm and then the other people that I'm familiar with. I think for most of us who are familiar with the process and who do this regularly, I mean, this is our main business. Most of the firms that do that, we're very familiar with what these claims are going to entail. And so we've been working up these cases now for a couple of years. So we have a huge number of cases that are ready to go and are going to be submitted. I think there are going to be other firms that are going to take a longer time to do it. So no one thinks that all of the 77,000 individuals, and that works out to roughly 25,000 actual cases, as we refer to them, which are properties or businesses. We think there's roughly 25,000. So, and that, for example, 77,000, but if you have a family of four, that's one claim, and that's why it's so much less. So if you look at those 25,000, I think there probably will be a substantial amount that will be submitted within the first 30 days, probably a third. And what the claims administration people are going to do, and this is why they wanted everything automated, is basically just to run all that through and then make some assumptions in terms of what the budget is going to be, what the holdback is going to be, and that's what's going to take them so long. It's not necessarily processing the claims, it's figuring out how much they're going to have to hold back, because they obviously can't pay out 100 cents on the dollar until they know what the percentage is going to be. We certainly hope they eventually can, but certainly at the beginning, they have to assume that there's not going to be enough money. So they're going to use that initial couple of months to figure out what that initial payout is going to look like, and then they'll start paying it out. So I think that's how the process is going to work. There'll probably be about a third that'll be put in very quickly. Then there'll be another third that are taking longer to work up, whether it's a complex business loss, something like that. And then I think there's going to be a substantial number of people who just take a long time. One of the things I never understood, but it just happens, is that some people really wait a long time. I mean, for example, in Butte, even though the fire was in 2015 and PG&E didn't declare bankruptcy until January of 2019, we had people at the very end who still hadn't submitted all of their information, even though it was 3+ years post-fire. So there are going to be people that are going to delay. And obviously there's a significant number of people that are unrepresented, somewhere around 10, 11,000. Those people I don't think are going to be at the front of the line, simply because they're going to have to figure out how to do it. And you know, they don't, most of them don't have any training in this. So I think it's going to go in stages. There's going to be that initial kind of, for lack of a better term, rush for people that are ready, are going to get their information in. Then there's going to be a second wave that's going to be the more complex cases. Then they're going to be, for lack of a better term, the stragglers. And they're going to be dealt with, you know, when they get their information in. Right now, the claims resolution procedures say everyone has to have all of their information in by December 31st of this year. I don't think that will hold. I think the trustee will extend it, whether it's 90 days, 180 days, or whatever. But there is going to be at some point a deadline. Everybody has to get their information in. And then once that's done, then they'll be able to make the determination how much of that holdback will we be able to pay out to everybody. Is it going to be enough to pay everyone 100 cents on the dollar? Is it going to be 90? What is it going to be? We'll learn that at that point.
Okay, thank you.
Sure.
Carlos Castle and Betty Castle, Magalia, California.
Yes.
So our question is that we had two family members that were in our home, and it amounted to 9 people altogether in my home with my wife and I. And we all ran, of course, that day. We were very fortunate we came back to a home. What happened was that we, out of pocket, my wife and I, had to put these individuals up in a motel in order for them to wait this scenario out. Is that compensationable?
Yeah, it certainly is compensable, but the thing we have to be careful of is that it's not double claimed. So you can claim it or they can claim it, but you can't both claim it. So that's what we have to make sure happens.
Okay, so hypothetically, if the family, of course, they have moved out and thankfully they've gotten a place to stay. My aunt who was living with me at the time, is a direct family member, and she was relocated all the way out to Yuba City to another family member, and then had to, resolve her own scenario. Would she be under our claim, or she should do that individually?
Well, in terms of the emotional distress, everyone has to file their own proof of claim. Good. So if she hasn't filed one and she wants to recover for the emotional distress she experienced when she ran, she can file an application for a late claim, and then they either grant them or don't, depending upon the circumstances. Thus far, they've been granting most of them, so she probably can still do it. But in terms of the out-of-pocket, that really should be whoever paid it. So if you paid it, even though it was on her behalf, it was part of what you had to do for your household for the fire, you're the one that should claim that. We just have to make sure that she doesn't also claim it, because then that will set off red flags if both people are claiming motel bills for the same person, same day, and we don't want that to happen.
Okay, and then the last question is, which is very troubling. So I was trying to get my insurance company to work with me with the ALE. And they didn't provide enough ALE at the time, so I ended up having to go out and get a signature loan from my bank in order to accommodate the ALE offset that they didn't have. Lastly, and the most important of all was during that time, my wife and I have several receipts that we held on to. Should we be taking the ALE information they paid the hotel for us, not for the others? Because we had, like I said, we had to pay that out of pocket. That's where the $5,000 came in to accommodate that off of our checking account. So we're concerned is if hypothetically the the Smith family that was with us, if they claim, distress, but not any just ALE kind of scenario, would we claim that on their behalf? Or that's where I'm confused.
Yeah, I think what you want to do here, and this is a little bit of an unusual situation, is I think you want to explain, here's what I had to pay out as a result of the fire, and here's why. And you lay out everything that you did. So you can say, for me personally, for my wife, our insurance company paid our ALE benefits, so we're not making a claim for that. However, I had these people that I was responsible for. The insurance company wouldn't pay for them because they weren't covered under the policy. So I had to pay that amount of money. Here's the amount I had to pay. Here's the proof. I think that's something that should be readily apparent. I mean, certainly that's something I'd be happy if for some reason the trustee said, no, we're not going to honor that. That's something I'd be happy to fight about because that seems completely reasonable. It's obviously a nice thing to do. And you didn't have any choice. So it really was something that was that was proximately caused by the fire, so you should be reimbursed for it.
Well, exactly. My language is that we would have not had to do that if the fire had not occurred.
Exactly.
Lastly, and lastly, so we had an insurance company issue with this. They dropped us in the middle of all of this problem, and it was sad that we didn't find out, but by our mortgage company and not them. So I'm not sure what the actual moratorium date was for the insurance companies not to be allowed to be dropping you, but it was very uncomfortable to find out by your own mortgage company that they're going to put on a quote unquote lender's insurance. And I'm like, okay, but which I caught it fast enough. We only charged us $59, so we were okay with that. But the reality is that isn't it the responsibility of the insurance company to actually contact the individual, not the mortgage company?
Oh, absolutely. Now, the only thing could be, and I'm certainly not making excuses, I'd have to see what the arrangement was, but if the mortgage company were the ones who got the insurance for you originally, then I could see the insurance company contacting them. But if it's something that you contracted directly with the insurance company, then you're the insured. There's no question under the regulations, they have a duty to contact you.
Yeah, because initially Wells Fargo had Century National, and I went to National General. National General, I guess, was a subsidiary of each of them. I guess, I don't know, but that's where that little sticky and gray area is. Even though I went there, it was still a product of Wells Fargo, I presume. Because it still seemed like it fell under the Wells Fargo branch of insurance. I'm not real positive that I didn't research it, but I went from Century National to National General, and next thing I know, I'm getting a letter from the lender saying, "Hey, look, your insurance has lapsed." I'm like, "Wow, what are you talking about?" So it's not that it's a big deal. It's just that I didn't know how long the moratorium that was set in place by Governor Brown and Governor Newsom, they had dropped us too soon before the moratorium was up.
Yeah, we'd have to take a look at that. If you want to send us the information, then I can have our insurance expert take a look at it and we can let you know. Off the top of my head, I don't know, but I'd be happy to look into it.
Sure. So that would be still at the information at SLFFIRM?
Yeah, it's just email it to me. So it's Gerald, Gerald, at slfsamlarryfrankfirm.com.
Okay, Gerald, thank you so much. And
Sure
I
thing.
believe that's all the questions I have. Thank you.
All right, who's next?
Hello, Gerald. How are you?
I'm well, and yourself?
I'm just doing wonderful. So my daughter is living in the house with us. She's 30 years old. The house burns down. All of her stuff is gone. Our stuff's gone. Everything's gone. She's kind of an unstable mental person. So we don't take any FEMA. We don't take any fire assistance. We have our insurance. I'm very careful about the government getting in my back pocket. And I didn't sign up for a lot of the freebie stuff that, you know, was optional out there. She went out and started, she went to everybody and basically used our address, possibly as a homeowner, possibly as the property owner, and received substantial amounts of money. She was your client, but she went out and talked to somebody else and signed up with them. I turned that information over to Joanna to make sure that she was excluded.
Okay.
So when FEMA or the trustee puts all this together and finds out that these funds have been dispersed to somebody that didn't necessarily have the right to ask for them, how is that going to complicate my situation?
Well, unfortunately, that may end up getting sticky. And it could be something where FEMA is not going to be seeking the reimbursement, but the problem is, if she signed a document from the federal government asking for money and put something false in it, then depending upon the language in there, a lot of times they require you to sign those under penalty of perjury. That could be a real problem. And so, you know, I don't want to be unnecessarily alarmist, but that may end up being something where they could look at it for prosecution. They could just say, we're going to deduct this amount from the proceeds that go out to this address. It's gonna, again, it's gonna be a little sticky. We'll have to wait and see what happens. Go ahead.
On the other hand, I specifically at the very beginning was able to get the name of her new, quote, representative, got that over to Joanna. She said she eliminated my daughter from us. And then I come to find out that she went and also went to the Fire Assistance Fund and was able to grab another $5,000. Well, in doing this, I kind of know that, you know, you just can't do this if you're somebody renting a room.
Yeah.
Those numbers don't coincide with that. So I figure she had to maybe do some other things. But she is now filing her thing through a different attorney. And of course, we're using you. I wanted to make sure all of this was above the board for us because, you know, we're the homeowner. We lost everything. She had a small area with a small amount of belongings, and it kind of ended up that way. What do I need to do with you to make sure that I don't have issues with people?
Well, you know, again, first of all, I'm very sorry you're having to go through this. I mean, that's a difficult position for any parent to be in.
Yes, it is.
In terms of, I don't think there are going to be a lot of problems for you. Unfortunately, there may be some for your daughter, depending upon how closely the feds look at this. But my hope is this, that the way they're supposed to do it when they cross-reference and deduct for any payments from the Wildfire Assistance Program or anything like that, is they're supposed to use the name of the person who applied. So again, that's my hope as to what they do here. So if they do that, then anything that was paid to your daughter should be deducted from what she receives. The concern that I have, and this is something that we're going to have to pay attention to, is whether or not they're going to do it by address. It wouldn't apply to the Wildfire Assistance Program because that is by individual, it's by name, so that's not going to be an issue. But in terms of FEMA, if she was able to receive money as an owner, and FEMA is asserting that they want that amount deducted from what that address receives, then it conceivably could come out of your amount. Now, we'll be notified of that. So at that time, we can talk about what options you have. But, you know, unfortunately, and I'm happy to talk about with you offline about this,
Sure.
just unfortunately, it may be that you would have to say, my daughter made that, not me, so she's the one that needs to pay it. And again, I know that's a terrible position to be in. So we should just talk more about that offline. But again, I'm sorry for that situation.
Do I talk with you or Joanna?
That's one that we should both be involved in. So just let Joanna know, and she'll set up a call with all three of us. But I'd like to weigh in just because that's a little bit out of the ordinary. And anytime you have those unusual situations, I like to make sure I'm involved.
I'm probably pretty sure I'm not the only one that's in this position. So,
Yeah.
All right. Thank
All
you
right.
much. Appreciate it.
No problem. Take care.
Hey, Jerry, it's Amber once more. Can I ask another question?
Please, go ahead.
Okay. So just as people are discussing their situations, it sort of occurred to me something I hadn't brought up, which is I have two children, and both of them are now attending private schools. That sort of the quality of the public education from the homes that we moved to, the districts were quite lower. And then the costs were quite higher because we moved to Santa Cruz County. Do you know, and it's not something I thought of submitting to my, for additional cost of living within, I didn't think of that as within scope by the insurance firm. Is this something that could be a part of a submittal? Do you have any general advice on that?
You know, my view on those kinds of things is that I'm 90% sure that they will not pay for the additional private school tuition. They'll say, if public school is available and you elected not to do it, that's a decision that you're certainly entitled to make, but they're not going to reimburse you. But I do think that's something that's going to come into the calculus when they're talking about the non-economic, because that really talks about how your life has changed. And if you go from a situation where you're in a school district that's very good, you're very happy, and now all of a sudden you're in a situation where that's not the case, and so now you're having to send your children to private school, then I think that's a factor that weighs in, and I think it's something that should be talked about. For your children, obviously the most significant thing is going to be that they're uprooted and they go from being in a situation where their friends are and they probably had been there for quite some time to now being in a brand new school. And any of us who have done that know how difficult that is. So those are the kind of things that we want to put in. But I don't think you're going to be able to recover for the economic.
Okay, thanks for the clarification.
Sure. All right, who's next?
Hey, Jerry, I have a few questions here via email and a few via chat. I'll ask a few and then open it up again. One of it, there's some confusion. It says here that the Fire Victims Trust stated that they were ready to receive submissions July 1st. Can you explain why we're waiting for August 17th?
Yeah. What they meant by that, and it is, I wish they hadn't said that, but they did. So it is what it is. What they meant was that if you wanted to submit documents that were not accompanied by the questionnaire, you were free to do that. And while I understand why they want documents, because it helps their overall numbers, my view is I don't want to take a risk that anything is going to be put in that might not be calculated into my client's claim. And so if I submit everything at once, the questionnaire, and then attach the other things to it, then I know that everything is being submitted, and I have a record of that. So that's why we are not submitting anything, because again, they're not going to start the individual calculations until they get everything in. They were just asking people to submit because, for example, if 2,000 people submit arborist reports, then, you know, that's a data point that they can take and say, okay, well, we have 2,000, the average is 100,000. So that gives us an idea of what to expect. And again, while I understand that may be beneficial to them, our main concern is our clients. So we're submitting everything for each client at once rather than piecemeal.
Thanks, Chair. I have another email here that says, how do we know when our case is going to be looked at for payment? Do we get an email, a phone call? And also, is October the earliest we can get the payments will start?
Okay, so two questions there. We'll address the second one first. I think yes. Again, they haven't committed. What they've said is as soon as we get the data that we need, we're going to start making the first payments. So the initial date that the trustee gave us was October. It definitely won't be earlier. It certainly could be later. Obviously, we hope it's not, but we'll have to wait and see. The date the trustee gave us was around Halloween, so late October, and we'll just have to wait. But it definitely won't be earlier. In terms of the other question, when will you know? If you are someone who wants to review either some portion or all of the information before it gets sent in, then we need you to just email us. We'll make that note and we'll send it to you. Otherwise, we'll submit it. And then what will happen is they will present us with a written offer that sets forth what the amount would be. We'll then obviously notify you and say, here's what the offer is, here's what we think of it, and here's why we think it's either a good amount, a decent amount, a bad amount, whatever our opinion on that is, we'll let you know, and then you'll make the determination, do we want to accept this, or do we want to go into the appellate round, and everyone has the right to do that, where it basically will start again, and there'll be a whole separate group that will look at it, but it'll be de novo. And so what that means is new. And so what could happen in round two is you could end up getting less. And the reason that they do that is if it's not a good offer and you want to appeal it, then by all means you should. But what they don't want is for people to say, well, wait a minute, there's nothing that I can't get hurt in any way. Why wouldn't I just appeal it and see if I get more? Because that will slow everything down, and it will also increase the costs for the trust because they have to have someone who looks at each one of them. So that's the way it'll work. And again, anytime you get an offer, we'll let you know whether we think it is fair or whether we are recommending that you appeal it, and then that decision will be yours.
Thanks, Chair. Also, can you, it says here, for the cases that were recently paid out, like Butte, did that settlement money come from the trust, or is it separate funds?
No, it's separate funds. So there were 52 cases that were in a very unusual situation. They had settled. PG&E had made a final offer. They'd sent us a settlement agreement. It had been signed and fully executed, but the payments were not made prior to January 29th when PG&E declared bankruptcy. And 30 of those cases were ours, and then I think 22 were, I think they were Amanda's or somebody else's. But in any event, so our 30 cases were paid out 2 weeks ago. And because those were pre-filing, the way that the trust looks at it is or the way the bankruptcy law looks at it, because they were fully liquidated prior to the date that PG&E declared bankruptcy, they are separate. They're not part of the trust, and they had to be paid out of PG&E's general operating expenses. So those 52 cases were paid out of completely separate funds. It does not affect the trust in any way.
Thanks, Chair. Via the chat, I have a question here that says, for non-economic impact after the fire that involves things such as separations, do we need to submit new rental agreements and costs if we have that we have at time of submission, or anticipated if not yet moved out, even though we're separated and living together?
Okay, so the answer is it depends. If, for example, you separate and therefore you need essentially two, you both need to get a place, then you can submit two ALEs, and that would be reasonable under the circumstances if you've separated. So if you're going to make an economic claim for that, then you would obviously need to submit the documentation to support that. If you're just talking about non-economic damages and you're going to say, one of the things that happened after the fire is, we moved from a large home to a small home and we fought a lot and we ended up separating, then you certainly don't need to provide any documentation of that. You can just put that information in there. So again, it depends. If it's economic, then yes, you'll need to submit it. If it's non-economic, then you don't.
I have a question.
Sure, go ahead.
Yeah, this is Leellen Loving. I talked to you earlier about not getting an answer from my emails.
Right.
I am really appreciating these town halls. So I have a separate question. Yeah. So my concern was I want to keep my Medi-Cal. I don't want it to be compromised. Do I need to talk to your office about setting up some kind of a trust before or after I receive the offer of compensation?
Okay, that's a great question. Now, there are, I want to say a couple things here. One, I have to advise you that I am not an expert in this particular area of law. However, it comes up a lot. So what we've done is we work with a firm in San Diego called Battaglia and Walters, and they are experts in this. So anytime we have a client who has a question about any type of a benefit they receive, then we give them the information. We have you talk with the people at Battaglia and Walters, and they can tell you exactly whether or not whatever benefit you're receiving will be affected. And there are different rules that apply.
Mm-hmm.
So you want to make sure that you talk to an expert. So please just put that in the email and we can put you in touch with them. They can give you the advice you need. And for example, if it's a situation where you are going to receive money to replace personal items that are lost, but if it all hits your account at one time, then you lose eligibility, then there are ways we can structure that. So you'll be able to replace the items you lost, as you should be able to, without losing your health insurance.
Exactly. But then again, my question is, do I want to do that before? Do I want to do it now?
Yes.
Or do I want to wait? Okay. Do it now.
Sooner, yeah, because those take a while to set up. So please include that in the email. We'll put you in touch with them, and please contact them sooner rather than later because we want to make sure that's all set up.
Okay, so I did check my incoming emails, and there's some kind of little encryption thing on there, and it just kind of makes me crazy. I'm not good at, my phone is my computer.
Got it.
So would it be an imposition for me to, I will try to email you, I will, but is it an imposition if I just call your office and try to talk to a person?
Yeah, just and these are things that I should talk with you about. So just you can ordinarily, I would say, talk to Erica, but she is out for the next few days. So you can either talk to me, or if I'm on the phone or I'm not in, then I would say ask to speak with Corey. And
Corey.
She can either, if she can't answer the questions, then she'll get them to me and I can respond. But Corey is one of our head paralegals in San Diego. So if you just call my office number and ask to speak to either Corey or Chewy, who monitors these and runs them, either one of them can help you. And if they can't answer the question, they'll get it to me and we'll get back to you.
Okay, great. And then just, you mentioned that the payment that for your legal work will come out of the settlement, and it is determined by how much time you spend with each client. Is that correct?
No, it has nothing to do with that. So it is a
Okay.
percentage of the total amount. So
I
it's,
see.
yeah, it's not dependent. So when you call us, you're not running the meter. You please feel free to call us, yeah, as much as you want.
Right. And is it a third percent? I'm just asking these questions to clarify for everybody.
Sure,
Is it a
yeah.
3%, 30%?
It's 1/3.
I don't remember.
Yeah, it's
1/3?
1/3 of the total amount.
Right. Well, I don't think that's arduous. I really do appreciate all your efforts on our behalf.
Sure thing. My pleasure.
So, this is Leellen Loving, over and out.
Okay.
Okay.
All right.
Bye for now.
Joey, do we have any other questions?
Mr. Hamburg has his
Yeah,
hand up.
Jerry.
Oh, for heaven's sakes. Oh, am I here? This is Phyllis. Can anybody hear me?
Jerry? Yeah, Mr. Wilbur, go ahead.
Hey. Hi, Jerry. Questions are clearly the ones that you do a great job of accommodating. I'll try this up to a 10,000 foot view. And can you hear me?
You're cutting in and out. It's a little difficult. I think we lost you.
Connections on his end. Mr. Hamburg?
It's Mr. Wilbur. He's cutting in and out.
Yeah, I think he has audio
Okay.
issues.
Can I
All right.
ask
Well, I'm
about-
sorry about that, Mr. Wilbur.
Can I ask one more question while we're waiting for Mr. Wilbur?
Yes, please.
So I have a question about the 1099s because
Right.
I'm realizing, wow, that's a big deal.
Yeah, we do not want that to happen.
Okay, so you're always so proactive in letting us know what's going on. So you'll let us know as soon as you get the word on how they're going to deal with this. I assume there wouldn't be a 1099.
And you're right. There should not be. There never has been in prior cases. I think what's happening is that the trustee is getting advice from people that are not familiar with this area, and they're giving him just the broadest belt and suspenders. This is the safest thing to do, which is right. But again, our view is, look, this trust is set up for the benefit of the victims, not anybody else. And so if there is a legal way to do this, which we strongly believe there is, then we want it done that way. Obviously, no one's saying we want to do anything that's not appropriate, but
Sure.
we think we can do it, as we always have in the past, without individuals receiving 1099. So we're really going to focus on that.
Okay, great. Thank you.
Sure. All right, who's next?
Oh, okay, I'll be next.
Sure, go ahead.
Ron Hamburg.
How you doing, Ron?
Well, okay, well, I'm used to being on Zoom on other matters, but I raised my hand and I can't put it down right now.
Don't worry about it.
I keep hitting, okay. So I just wanted to sum up the question I had in the meantime. Is there a case number that I need to reference if I emailed you? Or do I just state my name in an email, and is that sufficient?
Yeah, just if you want to put the name of the fire in the subject line, that's the best way to do it. You can just put PG&E bankruptcy, or you can put campfire, whatever's easiest.
Okay, and thank you for this format. And so the email is it gerald@slffirm.com?
Yes.
And that's what, okay, well, I believe the last email I received from you all contained, it was quite lengthy and had 4 documents to look at.
Right.
And, that's a lot of stuff to go over. And
you don't have to look at it. I don't want you to feel like you have to look at it. We just wanted to make sure we provided it to you.
Okay, and I just wanted to be sure there wasn't an additional document in the midst of all of that that I'm supposed to respond to.
No, absolutely not. The reason we attached them was that a lot of people had expressed interest in learning as much as they could about the trust and its functioning. So we attached the 2 pieces of information that they gave in terms of what information they would want. We attached the claims resolution procedures and then another document just related to the trust. That way, if people wanted to look at them, they could. But again, it's very lengthy. You don't need to fill anything out. That's just in the event that you want to look at it.
Okay, and I'll try and make this my final question.
Oh, no, yeah, go ahead.
When the claims are submitted, someone else may have asked this question, is there a way that we know that it's submitted, and do we actually see what's submitted in our name?
Right. So because everything is submitted electronically, no, we don't, you don't see what's submitted, but we can give you anything that you want. And again, if you want to look at it before, please just send us an email saying, I'd like to review either all of it or part of it, whatever it is, and we can let you review that before we submit it. Otherwise, we'll go ahead and submit it, and then we'll let you know once we get a response back.
Well, I presume that I've done everything I should have done up to this point. And so I don't want to trouble you or even do it if it's being done.
Sure, here's the thing, it's completely up to you. Some people are more comfortable looking at it, and that's fine. I mean, we're here to do what our clients want, so we can send it to you. If you don't want to, the quickest thing will be, we'll just submit it, and then we'll let you know as soon as we receive a response. And a lot of times they'll ask for more information. So if they respond and say, you know, we need X, Y, and Z, then we'll let you know. Otherwise, they may just wait, get the offer, and then send that. But as soon as we receive any response, we'll let you know immediately.
Very good. Thank you so much.
Sure thing.
Hi, Jerry. Hello.
Hi there.
Can you hear me?
Hey there. Yes, I can. Go ahead.
Hi. You know, I got to thinking about something you said in one of the last town halls about Morgan Stanley and handling the stock. And you mentioned that they were going to discount their work, something like 10%.
Right, they're going to donate, and I just wanted to let you know, sorry to cut you off, I just wanted to let you know what happened there. A number of people had said, instead of donating the 10%, why can't they reduce their fee 10%, which I thought was a great idea. So I raised that, and apparently they are not willing to do that. Apparently they want the publicity or whatever it is of doing it, but they are going to donate the 10%. So anyway, I'm sorry, go ahead.
Yeah, I just thought, gee, who would be more, who would be more worthy of getting it than all of us across the spectrum, everyone, your clients, all the clients, even people who aren't represented, for being, whether than a specific charity, the coffee park or whomever. And I thought, well, can we make ourselves a charity if that's the only way there? I'm serious, because it seems so, I understand it's to their benefit to donate because then they get a charity deduction, right? I mean, that's part of, I imagine, their thoughtfulness about this.
Right, no, absolutely. And I think that what's going to happen is that they're going to donate it to, you know, some of the more established charities in the area. You certainly could, and if you do, I'm happy to submit it. But my guess is that they're looking more for, you know, more established. Although again, if you did a general fire charity and you know, put it together, like I said, I'm more than happy to submit.
I'm not sure I'm capable of doing that, but
I hear you.
But I just thought, gee, it's really the people, all the people who are the victims, who should, not one specific thing or some other charity that doesn't. I just think that's a very strange determination on their part.
Yeah, I thought so too.
In their self-interest rather than.
Yeah. No, I thought so too. And I was saying, look, we can, you know, we can put out a press release, we can do all this stuff. And, you know, the answer was no. So, yeah.
Is there any way amongst the attorneys to file something that makes all of us a bona fide charity? Would that be something that would be difficult to do?
You know, I wouldn't, yeah, I don't know, because I know charities have to have specific purposes. So,
the purpose is to get compensated for
right. You know,
in a sense, they're taking money that comes from the trust and sending it elsewhere, which seems so counter
I
to
completely
Okay, I know
understand.
you're on the same page.
Yeah, no, and the problem is, I'm not an expert in 501c3s, which is what it would have to be. That's the IRS code. There may be a way to do it. I don't know how you would structure a charity where the beneficiaries would be the fire victims. You know, what would the criteria be? All those kinds of things. So I don't know realistically that it would be able to be done. I can't say it couldn't, but I certainly would not know how to go about doing that, unfortunately.
Well, you and me both.
Yeah.
Okay.
Got a question.
Yes.
Hello? Phyllis? Oh, it is. Oh, my good Lord. Hello. How are you?
Hi.
Okay, I've touched on this before, but now I'm going to retouch on it again.
Okay.
In the very beginning of time, like everybody else, there's no place to live. We go to Arizona. We just relocate. We actually do buy a house down here because we don't want a rental where someone's going to rip it out from underneath us. We're old. We want to rebuild in paradise, but we know that the value of the insurance is not going to now replace our house in paradise that we want to build on our property. We're not quite sure how to substantiate that. We've contacted our insurance and they said, well, geez, we're sorry you don't like Arizona. Are you going to sell your house or what? Well, we're going to have to sell our house down here, certainly, but that's not going to be able to afford to rebuild now 2 years later because everything has gone up so much. What do we do for our insurance claim? We're just wanting to know where do we go? I mean, is it the settlement we're waiting for? We think so.
Right. Right. I think that's how it's going to work, because what you're going to do is we'll have a cost of construction and what it'll take to rebuild your home. And then obviously the difference between that and your insurance is what you'll get from the trust. And so if you elect to, for example, sell your home in Arizona and then rebuild, then that's something you certainly could do.
But we can't sell our home in Arizona and rebuild until we get our settlement. And then we have to sell and find someplace to live while we're rebuilding. That's going to take another couple of years. Insurance told us we had 2 years to do something.
Okay.
Yeah, that's my
Okay. So now typically there is an extra year that most of the insurance companies agreed to. So again, we have to look at your policy, but if you haven't talked to our insurance expert, I think that's the way to do it. Have you spoken with Joel Alba?
I'm not sure if Joe, I think so. He had a rebuild estimate done on our house. Is he the one that does that?
No. Joel is, he's a retired insurance. He was, started off just being a routine adjuster. Then he eventually went into management, but he was in the insurance industry for 30 years, worked for a lot of different companies. So he has a really good feel for these types of cases. He's retired now. We hired him as a consultant, and we just make him available to talk to our clients to answer their insurance questions. It doesn't cost anything. It's just part of the service. So what I would recommend is speaking with Joel and having him take a look at your policy, and then he can give you what your options are according to the language of your policy.
And to get a hold of Joel, do I also say, hey, I want to get a hold of Joel? I send a message to you?
Yeah, just email me and I'll email you his information.
Okay, that would be great. Thank you very much.
Sure thing.
Hey, Jerry, I have an email that I just received a few minutes ago.
Okay.
It says, if the more complicated claims are likely not to be submitted until the second round of submissions, might that make it more difficult for the trustee to, after the first round of submissions, accurately predict the amount of money to hold back?
Yeah, that's a really good question. And that's why they've been asking us for our estimates as to our business loss and more complicated claims. The answer is yes. And that's why the trustee is going to err on the side of caution. So let's say, for example, the trustee thinks that they're going to be able ultimately to pay out 90%, that's their projection. They're definitely not going to pay out 90% at the beginning. They're going to pay out something significantly less than that, maybe 70, 75, whatever, to account for that. Same thing. If after their initial projections, they think it's 75% that they'll be able to pay out, then they'll pay out 50. The way that they're going to do it is that they're going to make sure that they hold back a large amount so that there's no chance that they're going to shortchange people that get their cases processed later. And then if they end up having more money than they thought, great problem to have, and then they'll just pay it out then. So that's a really good point, but they're definitely factoring that in, and they're going to err on the side of caution.
Thanks, Jerry. Another question here is, being 90 years old, are we going to be paid quicker than other younger individuals?
Yes, the answer to that is yes. In fact, that was one of the things we talked about today. Several of us had brought up that we believe that the trustee should use the same procedures that are in place in Superior Court. It's a specific section of the Code of Civil Procedure, Section 36A, which says that if you're over the age of 70 and you have a significant health issue, then you're entitled to have preference in terms of when your case is resolved. Essentially, you move to the front of the line. And so we brought that up with the trustee. He's been considering it, and he says he's going to do something like that. So people that are older and have health issues, you will be able to essentially move to the front of the line and have your case determined among the first group.
Thank you. How will the payments be sent to us? Will it be via regular U.S. mail?
It depends. Usually what we do is the money will come to us. We will prepare a breakdown, and then we'll explain to you, here's how much the fees are, here's how much the expenses are, here's how much you get. You review all that. If you agree, you sign it, and then we'll issue the check however you want. Some people want, husband and wife name on it. Some people want it all in one person's name. And again, as long as it's legal and everybody agrees, then that's fine. Usually we send it out regular mail. There are situations where people prefer that it be, registered mail or certified or, some other arrangement. Basically, just let us know, and we're happy to work with you so we can take care of that.
Okay. It says here, I understand your point about the de novo appeal. However, is there any reason to believe that the initial adjudication process will be decided more conservatively to weed out claimants early?
Yeah, that's a good question. The answer is I don't know. There's one school of thought which says that they're going to be conservative at first because they don't know how much they're going to have. There's another school of thought that says that they want that first wave of people to accept the amount and not to appeal, which would mean they're going to be more generous. I really don't know. I could see it either way. Obviously, their position to us is we're going to be fair and the first person is going to be treated the same as the last person. So, again, we don't really know. My guess is that it's going to depend a lot on what happens with the stock in terms of whether people at the front get treated any differently than people at the back. I think if you're one of the last people whose case is decided and the stock has gone through the roof, you are probably going to get more money than you would have gotten if you'd have been the first person decided. On the other hand, if the stock takes a dive, then the reverse could be the case. So, you know, I mean, obviously ordinary human factors play into it, and the trustee certainly is going to know what the stock's doing and how much money is available. But I don't know that there's necessarily a rule of thumb that the first people are going to get more or less than the last people, because I think it's going to depend on so many different things.
Thanks, Chair. Who determines the value or compensation for the emotional trauma and other non-economic damage? Is it you
Right.
or the trustee?
No, it's actually the claims administrator. The way that it's going to work is that we put in the information, and then the claims administrator is going to decide what each component is worth. And that's how they're essentially going to do it. So they're going to look for there's going to be certain baselines. In other words, if you were within the zone of danger, so you had to flee for your life, then that's going to be 1 point. If you were, you know, fleeing for your life because your house was on fire as you left, that's obviously going to be much more than someone who legitimately was in fear, but was a much farther distance away. You know, if you had to evacuate with an elderly parent or a young child, you know, those are things that are going to be factored in. All of those things get factored in, and then they'll make a determination. But they've told us not even to put in an amount for non-economic. They've said just list what the factors are, and then we will make the determination. And if your client is not satisfied, then they can appeal. Thanks, sir. I have, look, I'm trying to scroll through here. Looks like I might have missed something. It says here, I suggest the 10% in reduction of fees from the broker be donated to the Paradise Parks and Recreation Department for a specific project that can have some type of plaque associated with it. That way, current and future residents benefit from it. Yeah. Yeah, if you could just send us, it does have to be a 501c3. So it has to be a charitable organization. It can't be to the city. They've, you know, they've settled for a large amount. And so they want it to be to a charity, but there are charities that are working in all the different areas. So if anybody has suggestions, please forward them to me, and we forwarded them to the trustee, and I think there's a person from Morgan Stanley that they're going back and forth with, and then they'll make their decision. It's certainly not all going to go to one entity. So if there's $1 million that they're going to donate, I think it'll be split among several, if for no other reason than I think they want to be fair. You know, they don't want everything to go to camp or everything to go to Tubbs or everything to go to Redwood. They want to spread it out amongst different charities.
May I raise?
And
hang on one sec, Julie. I think somebody was speaking. Go ahead.
Yeah, this is Bruce Persons again.
Go ahead.
If I may raise a point of order, or not a point of order, but just a point of fact, is that the city government of Paradise is having some very unsavory political maneuvers, according to most of the residents that still live there. That being said, having a donation towards their city parks would not be a good idea because of the way that city's political situation is. Okay, so that's enough said. My other question was, is there going to be an option to direct deposit when the checks are made out?
In other words, to wire the money?
Right.
Yeah, if you would, usually we do a check, but
okay.
If it's better to do a wire, just let us know and we can talk about that.
Okay. Is that because of your accounting procedures?
Yeah. Yeah, it's the easiest thing for us, for our accountants and for everything, is when you have the actual check, then there's no doubt, because we take a photograph or we photocopy that, and we put it in everybody's file, and then it's very easy. There are records of a wire transfer, but they're nowhere near as precise. And you know, it's much easier to prove that you paid the money if you've got a check, which is why we typically do it. But
Okay.
yeah, you know,
Okay.
again, we understand that circumstances sometimes require it, and we're happy to discuss it if that has to be done.
Okay, all right, I'll raise that issue with Earl and, you know, see what he says. But you did mention earlier that the checks can be sent with a signature required?
Oh, absolutely, yeah.
Okay, all right, thank you very much.
Sure thing.
Okay, I have an email here that says, how many people do the claims administration have working on the cases?
This is based upon what they've told us, because I haven't obviously seen them, but they hired 200 people specifically for this. So that's my understanding. I don't know if that's, you know, could be 10 either way, but what they told us was they hired 200 people, and this was what that initial money went for that was released in April, is hiring the 200 people to build up the system and prepare this claims resolution procedure.
Okay, we can open it up again, Jerry. I got to scroll through to make sure I didn't miss anything.
Okay. Does anybody have any other questions?
I have another one here.
Yes, ma'am. Why don't we start with Ms. Salmon, and then we'll go to Mr. Haller.
Okay. Hi, I'm muted, I think. Okay.
I'm sorry?
So with 200 people, you know, each one is different. So there's also the luck of the draw there, right? You might get someone more generous or someone more, you know, careful about paying out a claim.
Oh, well, let me make sure I specify. When I say 200 people, what they're doing is essentially working it up. So they're saying, for example, let's say that in your situation, we have for example, a diminution in value report. And they're saying that what they would be doing is looking to check and see if the numbers that we are giving are within the reasonable range. So if the average cost of a property, if the pre-fire value in your neighborhood prior to the fire was $750,000, and we claim that your pre-fire was $1.5 million, then that would red flag it. And so that's what the 200 people are doing. It then goes to a very small group of people, the claims administrator and the other neutrals, and I think there's between 5 and 10 of them. And then they're the ones that look at it and say, okay, here's what the value should be. What the 200 people are doing are working it up and taking a look to make sure that the numbers that are given are within the reasonable range, or if they're not, they're flagging that so that they can request additional information.
Okay. And the additional is from you or from their own research people?
Well, typically what they would do is they would say, okay, this issue has come up. Do you have more information that you can provide? And we may or we may not. You know, certainly there are outliers, and that's going to happen. And so it may be that we say, look, we understand that this is the average. This was a very unusual house. Here are the pictures, et cetera, et cetera. And it may be that they accept that. It may be that they say, okay, we're going to do our own research. That's one of the things that I think is going to get fleshed out as we go forward. But my understanding is the job of the 200 people that are doing the workup is to make that initial assessment, give that information to the claims administrator and neutrals, and then if there's more information needed, to send us the request, we send it back to them, and then they make the decision.
Okay.
And I think Mr. Haller was next?
Yes, sir.
Okay.
So from what I understand, any monies paid to us, they're going to 1099 us and tax it. Is there
No.
any of these funds that are non-taxable?
Right. And that's why we want to make sure that they do not 1099 it. Right now, that's what they're talking about. And that's one of the things that we're fighting about with the trustee, because one of the things I was doing today was speaking with an attorney who's a tax expert who's going to give us an opinion saying that it's not necessary. We then take that, we go to the trustee, we work with his attorneys, and we're hopeful that we can come up with a solution, which is like we've done in every other case where you do not need to be 1099.
I have been in some other legal actions where I have been injured and I sued, and because of the injuries and whatnot, the substantial sums that were given to me were non-taxable.
Right.
And they did not cause problems with Social Security income and things like this. Are there special things that I need to watch out for because I am on Social Security?
Well, that's a complicated question, and it's a good one to ask. What I would say is this: it really depends upon the type of Social Security, because there's one type that has nothing to do with any type of income or
disability.
It's not,
in Social Security.
Right. So what I would say is, to be sure, you should talk with, we have attorneys that we refer people to. The firm is Battalion Walters, and I can get you the information, but they're experts in this. They could take a quick look at what you received, and then they could tell you whether or not it could be an issue.
Okay, I'll be in touch tomorrow.
Okay, sounds good.
Thank you.
Sure, it looks like Mr. Brewer has a question.
Oh, sure, go ahead. I think you're on mute, Mr. Brewer. There we go. I'm sorry, I'm not hearing you. Can you turn up?
I don't think he has his microphone turned on, Jer. Mr.
Yeah,
Brewer?
Mr. Brewer, I think the microphone may not be turned on.
Mr. Brewer, if you'd like, you can call my cell phone and I'll be more than happy to ask the question. You can call me at 619-537-9995. Jerry, I do have, while he calls me, I do have a question that says, so sometime around August 17th, will we be contacted to file or fill out our claim questionnaire? Or
No,
will
we'll
that
do
happen? Will that not necessarily happen based on materials already submitted?
Yeah, no, no one is going to have to fill that out. That's part of what we're doing. We'll fill that out, and then we'll attach all of the reports to it. So you will not have to worry about that. Shui, were you able to speak to Mr. Brewer?
I have not received a call yet. Once
Okay.
I do, I'll chime in and ask his question.
All right. Do we
I
have
have
any
a
other
question.
questions? Yeah, go ahead.
I do.
Please, go
This
ahead.
is Lee Ellen again.
Yeah.
So I was under the understanding that this settlement would be taxable, and sadly to say, I don't know what a 1099 is.
Sure. Generally, it's not taxable. There are certain rules that you have to take a look at. So what I always tell people is, I'm not a tax professional, so talk to a CPA or a tax lawyer. They can tell you. A 1099 is given, there's a ton of regulations as to when they have to be given. The most common time is when you do work for someone, but you're not an employee. So you receive a 1099 for the amount of money that you were paid. And so the concern that I have is, I don't want my clients to receive a 1099 and for the IRS to say, you got a 1099 for 100,000, you must have had 100,000 in income. We want the taxes on that.
Okay, so 1099 is what somebody who's self-employed has to file.
Well, not necessarily.
Kind of.
Yes and no. It can also be a contractor. So if you're you know, just doing consulting work for someone, then they can send you a 1099. It's the bottom line is it's a payment to a non-employee, typically for services rendered. And again, it's a very complicated area of law, but that's why we want to make sure that you don't get them.
I see. And so it was my understanding that we might be taxed for our settlement.
Yeah, the answer is it depends. If it's if you receive money for lost wages, for example, that's taxable. But if you receive money for lost personal possessions and you go out and replace the personal possessions with the money, then there's no taxable event because you haven't received any benefit. You've just been compensated for your loss. So that's kind of the rule of thumb, but it can get complicated. So if you have any questions, I would just talk with the CPA.
Okay, and this doesn't have anything to do with the FEMA grant because I replaced my lost personal possessions with the FEMA money.
Right.
Not, right. So it's a separate entity, so to speak.
Yes. Yes.
Yeah. All right. Well, thank you again.
Sure.
Okay.
Chewy, did we have any luck with Mr. Brewer?
Yeah, I have it's a question regarding how the cost or the cost put on ashes of loved ones, you know, such as wife, father, and aunt that are lost in the fire.
Yeah. Okay, so those are cherished possessions, and they can be obviously they can range from the ashes of loved ones to things like photographs of deceased loved ones, to you know, the card that your child made you when they were in kindergarten for Father's Day, any of those things, anything that doesn't have a fair market value. In other words, something that a third party is not going to be interested in buying, but to you had great sentimental value. Those are cherished possessions. Those are part of your non-economic losses. So you might have, again, the emotional distress for fleeing the fire. That's one category. Second category is how your life has changed as a result of the fire. And then the third category is cherished possessions. So what we always say is, please give us a list of the most important cherished possessions you had. And these really can range. It can be, you know, the flag that was given to you or given to a member of your family at the burial of a loved one. You know, for example, my father, one of his most cherished possessions is the flag that he got when his brother was killed in Vietnam. You know, something like that. That's not going to have it's not going to have a meaning or a fair market value to a third party, but it's obviously very important to him. Again, photographs of deceased loved ones, any of those. So if you can just list those out for us or tell it to us when we do the interview, then we'll include that, and that will be factored into the non-economic damages. Okay. Do we have any other questions, Chewy?
I believe I'm going to check my email. Not in the chat, but it looks like there's a few in the email.
Okay, go ahead.
Okay, so this goes back to the question about how many people the claims administration has working for them. And it says, so they have been drawing a check since April, and 5 months for the questionnaire. Can you please explain?
Yeah, so it's not for the questionnaire. It's, remember, this whole process had to be built out, and it's not just the questionnaire. The questionnaire is the smallest part of it. It's the whole claims resolution process. So, I mean, basically we had to start from, and not we, the people that did it, had to start from scratch because nothing like this had ever been done. And so that's what they've been doing. And again, I understand the frustration as to why it's taking so long. Everybody wanted to get paid right away, but you know, being on the Trust Oversight Committee and getting the reports back on all the things that they're doing, it really is a lot of work, and that's what's taking so long.
Thanks, Jerry.
All right, do we have any, let's see, it's about 7:15. Do we have any other questions?
There's one email that came through. It says,
yeah.
What is considered older when it comes to preference? Can you elaborate on
Sure.
that?
Yeah, the statute, Section 36A of the Code of Civil Procedure, talks about being 70 years of age and having a significant health condition. Now, obviously, as you get older, the level of the health condition becomes less important. You know, somebody who's 70 would be expected under normal circumstances to live another 15 to 17 years. So, you know, it's got to be fairly significant if you're 70 and you're asking for preference. On the other hand, if you're 95 and your actuarial tables are 1 year, then, you know, you really don't need a health condition. I've filed them, you know, I've filed dozens of these in my career. And when you file them for somebody in their 90s, there's really no opposition. When you file them for somebody who's 70, they're going to take a close look and they're going to say, you know, is this person actually ill? Now, you don't have to be terminal by any means, but, you know, if you simply said, I'm 70 years of age, but I'm otherwise healthy, that's not going to work. If you're 70 years of age and, you know, for example, you'd had heart issues or you're a cancer survivor or something like that, then that certainly would do it. But again, just think of it as a continuum. If you're 70, your health condition has to be more serious. As you get older and older and older, the type of condition, it becomes less important. And again, once you get into your late 80s, early 90s, because they look at actuarial tables, you know, it becomes a lot less significant.
Hey, Jared, I don't have any more questions in the chat or via email.
Okay, do we have any other questions before we
I have a
sign off?
comment.
Oh,
I have a
please, go ahead.
comment.
Yeah.
I got a call from Gary and he was very nice. Thank you.
Oh, good.
He's going to be a pleasure to work with. That's all I wanted to say.
I'm glad. Well, that's great. Okay, so we will do this again next Thursday. If you have any questions, please let us know. I know several people are going to email me, so I will get back to you. And again, thank you for your patience. We are getting a lot closer to this thing getting done, and please reach out to us if you have any questions. Take care.